state, my Lord.
Yes.
My Lord, I will repeat. This is the document that is before this court. There are other communications, responses from the author or from the DPP regarding the status of this letter. And the court has not made a final ruling on this document. We are still going to argue on merits, my Lord, as to which evidence should be accepted by this court and which evidence should not be accepted by this court. But at this stage, during trial, a defense cannot be prevented from conducting cross-examination, clarifying issues, facts that are contained on each and every document that is before court, my Lord, especially when it is in relation to the witness who is testifying. It's not a new document that I'm introducing, my Lord. It is before court. I understand the letters have been sent as like the one I've just read, but we are still going to make the submissions regarding the credibility of these letters. And
I hear what you're saying. But
yes.
The only issue I have is whether this witness
Yes, my Lord.
can testify on the contents of those letters, not having been the one who wrote those letters.
Yes, I agree.
This might be pointing us some direction, but my worry is when somebody sits in an office, probably in Joburg, and writes a letter, and we go to KwaZulu-Natal and pull somebody to come and answer on what is contained in those letters.
I agree with His Lordship. That is true and that is correct. My Lord, I am not asking about the whole content of the document, but it will be on a specific reference, which I think, my Lord, the court will overrule, which I think this witness maybe can respond to that. Not the whole content, but it's just those few paragraphs. And I'm not saying the information was given by this witness, but it's the information that is contained in this document that is before this court about the witness, my Lord. Not the whole content of the document, I understand, and I cannot do that because he is not the author, my Lord. But there are some references regarding the witness who is testifying, of which I just need him or to respond. If he can respond, if he cannot respond, there is no problem also with that, my Lord.
Mr. Madala, can you respond?
Ngakwazi ukuphendula kule nkulumo lesona zangu umeli ukuthi uzobuza ngamaphuzu athile ile document noma le document lethu.
Ngingakwazi ukuphendula only if sesiqale ngalento besithe soqala ngayo ekseni.
No, Mr. Madala, remember the defense is not bound to take any particular line in cross-examination. So forget about everything and concentrate on the question put to you. I'm saying somebody said, you heard me say, somebody said in Joburg and wrote a letter, who is a member of the police services. Now you are being asked about the contents of those letters or that letter. Are you able to answer?
Yeah, ngizophendula ngibuzwa ngale docket le.
No, not the docket.
No, I docket.
The portion document.
Okay. No, I can't ngizophendula.
There's no problem in answering. I'll give an answer.
Oh, you didn't hear the answer, the question?
No,
Can you
maybe
repeat
the question may be repeated for me?
Thank you, my Lord. In on page 9, my Lord, of Exhibit C.
Yes.
Paragraph 5. says accused number 1. Oh, sorry, my lord, can I just refrain from using accused number 1 because it will confuse the record. Let me just put the name.
Please, my lord, can I just get an indication, has the court already made a ruling? Because if not, we still want to pursue the point further, the objection, my lord, that we have raised. Can we allow, my lord, to develop that objection further?
You are? Okay.
Yes. My lord, we've indicated that Exhibit C has got no status at all. It will therefore be an exercise in lily-cuddling to spend any amount of time on that Exhibit C. We indicated at some point, my lord, that in any case that serves before a court, there are 2 issues, my lord, that usually need to be decided upon. The facts in dispute, as we mentioned, facta probanda, and the facts that are used to determine those facts that are in dispute. They say facta probantia. Any cross-examination that doesn't help the court to resolve those 2 issues, my lord, is irrelevant. We are therefore saying, my lord, that any cross-examination based on Exhibit C is of no force and effect because Exhibit C has got no status. A witness cannot be cross-examined on something that has got no status. My lord, that is the crux of our objection, and we request, my lord, that we should perhaps not dwell any further on Exhibit C and rather move along, because as we mentioned, my lord, that will be an utter waste of court's time, as Exhibit C has got no status at all. Thank you,
My lord, with due respect, cross-examination is not done because it will amount to a waste of a time, my lord. But the value on the line of cross-examination that I'm asking this honorable court to allow me to do, it is because this exhibit is a document that is before this court. And this court still has to decide on it, my lord.
But isn't this document, isn't there further indication that this document does not exist in reality? Because it is disowned by the very people that whom you say wrote it.
My lord.
And my feeling is that, how should I put it? My feeling is that we are now trying to get into a review through this case, which would not be proper to do.
My lord, I agree with his lordship, but my view, my lord, with due respect, is that this document is before court, and the state has responded to say the decision contained in this exhibit was taken by a junior. We're still going to address this court on that, my lord, when we're addressing on merits. And then there's another exhibit, my lord, above that, saying that a final decision has not yet been made, so it is still pending. And that letter makes reference to the findings of this trial, my lord. Therefore, my lord, that's why I submit with due respect to say, as a result of that the state has indicated that the final decision will be dependent on this, and the witness who is testifying is the person who has knowledge of the facts that I need to clarify with.
But then you put a pointed question to him to say, are you not testifying so as to avoid being prosecuted later? And he gave it. Now
Yes.
you want to go into the contents of the letter, which number one, he did not write. Number two, around which, the status of which is in contention.
My Lord, yes, I agree the witness has responded, my Lord.
Yes.
But the information that I was going to ask is not suggesting that he is still going to be arrested or is in line with what he has already responded. It's on something else, my Lord.
Yeah, but that document is disowned. That's why I keep on saying it now strikes me that we are doing something within something. If the status of these documents is that crucial, then maybe you should go the right route of setting the record straight around that, instead of us debating these documents on the basis that they may or may not be document that can be ascribed to SAPS. I think we need more than what is being said here, even more than what you are saying. And that being the case, to expect a lay person to express on them is even more unfair.
As the court pleases. As the court pleases, my Lord, I will move on, my Lord. May I ask for the adjournment, my Lord, in that regard?
Okay. Until what time?
It's 1:45, my Lord. If we can resume, it's 1:45 now. If we can resume at 1:45, just take a 1 hour adjournment.
Does everyone agree? Because the other problem is we agree upon time, and when we come back here, not everyone is here.
Or maybe at 2. We can resume at 2, my Lord.
Brother James?